All right, Commissioners. Well, I know that she is logged in, so I guess we can proceed and the technical difficulties get resolved. Perhaps we can
All right.
bring it back up.
All right, thank you. Morning, Ms. Miller.
Good morning, sir.
No cases to reconsider under agenda item 3.
Correct, no cases.
Let's move to tax liability cases under agenda item 4. I believe we have tax cases on dockets 3, 4, and 5.
Good morning. Yes, that's correct. For the record, Hugh Daniel, Special Program Appeals. There's one tax liability case on docket 3, 2 tax liability cases on docket 4, and 1 tax liability case on docket 5. The case on the first docket number 3 is TD-23-025-0923. Commissioner Esparza.
I agree with staff recommendations.
Thank you. Commissioner Trevino
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you. The first case on docket 4 is TD-23-024-0923. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff's recommendation.
and Chairman Daniel.
I'd ask to rehear the case to distinguish the status of cleaners whose written contracts contain additional requirements imposed by the firm.
So we do have a majority vote to agree with staff recommendation.
I'm gonna change mine to let it rehear.
All right, we will rehear the case. In the second case in docket 4, that's TD-23-028-1023. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
The last case is on docket 5. The number is TD-23-034-1123. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you. That concludes all the tax liability cases on these dockets.
All right, thank you. No fair housing cases under agenda item 5, no child labor cases under agenda item 6. Under agenda item 7, we have no wage claim cases on dockets 3, 4, or 5.
None pulled for discussion, but you should have received the wage claim short form dissent lists for dockets 3, 4, and 5.
I move we accept staff recommendations on the remaining wage claim cases on dockets 3, 4, and 5.
I second the motion, except for those cases in which I am dissenting as reflected on wage claim short form dissent list for docket 3, 4, and 5.
I concur with the chairman's motion, except for the cases which I am dissenting with reflected on the wage claim short form dissent list for dockets 3, 4, and 5.
Motion passes with the exceptions noted. Let's move now to agenda item 8, consideration of unemployment insurance cases. Starting with docket 3, please proceed when you're ready.
Case number 3223747, Commissioner Trevino.
The AT decision is not correct. I agree that the claimant established good cause for missing the AT1 hearing. Regarding the timeliness issue, although the claimant filed a late appeal to the determinations issued on 7/28/21 and 8/12/21, the claimant was not in claim status at the time these determinations were sent to her electronic correspondence inbox. The claimant received misinformation from commission representatives about her appeal. Therefore, the claimant's late appeal should be deemed timely and the case should be resubmitted on the merits. Modify the AT, claimant established good cause for AT1, timely claim and appeal, resubmit.
The AT decision is supportable. I agree that the claimant had good cause to miss the first hearing. Claimant's appeal to the appeal tribunal was late, and since her testimony provided no specific information on how TWC personnel may have misled her, none of the exceptions under Rule 32 applied to her late appeal. The claimant's late appeal leaves TWC without jurisdiction to consider the merits of the 3 prior determinations involving her ineligibility for PUA benefits, the overpayment, and her ineligibility for a waiver of the overpayment. Accordingly, we should affirm the AT decision. The claimant had good cause to miss the first hearing. The claimant filed a late appeal. The claimant was ineligible for PUA benefits beginning December 27th, 2020. The claimant has an overpayment of $6,979. and the claimant is ineligible for a waiver of the overpayment.
Claim established good cause for AT1, untimely claimant appeal, PUA not eligible beginning December 27, 2020. Overpayment waiver denied.
Short form dissent.
Yes, sir.
Thank you.
Case number 3525966, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant filed a valid claim. Regarding the job separation, the claimant provided persuasive firsthand testimony that he reported his availability to the employer by signing the employer's availability log the day his assignment ended due to this medical condition. The employer's testimony that the claimant did not report his availability was based on secondhand testimony and a blank logbook document, while the claimant's firsthand testimony was that there were other signatures on the logbook when he signed it in the employer's office. Since the employer offered no firsthand testimony to refute the claimant's testimony, the employer's testimony was less persuasive, and the evidence established that the claimant was discharged for reasons other than misconduct when he was not offered an additional assignment. Modify the AT, valid claim, no misconduct, void chargeback.
We should modify the appeal to tribunal decision. First, I agree with the validity of the claim finding. Regarding the job separation, policy required the claimant to notify the employer of his availability for work by signing the logbook within 48 hours of completion of his assignment. Despite being aware of the policy, the claimant did not comply with the reporting procedure. In fact-finding statements and in his first appeal, the claimant stated that he reported for reassignment by calling the employer. These statements cast serious doubt on a subsequent testimony that he reported and signed the availability logbook. Thus, in accordance with the commission precedent, because the claimant did not follow the reporting policy, he is considered to have quit without good cause connected with the work. We should modify the AT decision. Claimant filed a valid claim, voluntary leaving, void the chargeback ruling.
Valid claim, voluntary leaving, void chargeback.
And short form dissent.
Yes, sir.
Case number 3541088, Commissioner Esparza.
We should reverse the AT decision. The employer, the only party to attend the AT hearing specified that the claimant was on final warning for his job performance. Although the claimant was consistently provided additional training and opportunities for growth, the claimant did not follow direct orders from his superiors, whereby his performance waned. Since the claimant had met the employer's expectation but regressed upon failing to follow the employer's directives, the claimant mismanaged his position of employment. As such, we should reverse the AT decision, call misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for performance issues. The evidence established that the claimant never consistently met the employer's performance expectations during his short period of employment. At the time of discharge, the employer told the claimant that they needed someone with more experience who could keep up with the workload, and that they did not have the resources to continue training him. Therefore, the claimant's inability to meet the employer's performance standards did not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Misconduct, no chargeback, adequate employer response.
And short form dissent.
Yes, sir. And that was the last unemployment insurance case. Pulled for additional discussion on docket 3. You should have received the UI short form dissent list for docket 3.
I move we accept staff recommendations on the remaining UI cases on docket 3.
I second the motion except for those cases in which I am dissenting, as reflected on the UI short form dissent list for docket 3.
I concur with the chair's motion, except for the cases on which I am dissenting is reflected in the UI short form dissent list for docket 3.
Motion passes with the exceptions known.
Thank you. Proceeding to docket 4.
Case number 3135328, Commissioner Trevino.
The AT decision is not supportable. Regarding the timeliness issue, the claimant spoke to commission representatives during the appeal period and did not receive sufficient assistance in filing her appeal. This should be considered commission misinformation, and the claimant's appeal should be deemed timely. Regarding the claimant's PUA eligibility, the claimant filed a claim for regular UI and was initially paid on that claim. The claimant was later disqualified and her PUA claim was filed in October of 2021. But this was not until 6 months after the claimant stopped filing payment requests. Since the claimant had not filed payment requests for several months, she was not aware that she needed to monitor her mail and did not receive the request for proof of employment in a timely manner. Once the claimant received the document, she immediately submitted her proof of employment to the commission. Since the claimant was not aware that she needed to monitor her mail once she stopped filing claims, and she submitted her proof of employment once she received the request, the claimant has established good cause for failing to submit the proof of employment in a timely manner. Reverse the AT, timely claimant appeal, PUA eligible beginning 12/27 of 20, no overpayment, void waiver determination.
The AT decision should be modified. I agree that the claimant's appeal should be considered timely due to insufficient and misleading interactions with TWC staff within the appeal period. On the merits of the PUA claim, the claimant was ineligible for PUA benefits beginning on December 27th of 2020 because she submitted the required employment documentation after the deadline for doing so. The overpayment arose for the ineligibility ruling and should be affirmed. Since the claimant was at fault in creating the overpayment should not be waived. Accordingly, we should modify the AT decision. The claimant filed a timely appeal. She was ineligible for PUA benefits beginning December 27th, 2020, overpayment of $7,815, and deny the waiver of the overpayment.
Timely claimant appeal, PUA eligible, no overpayment, void waiver determination.
Short form dissent.
Yes, sir.
Case number 3338261, Commissioner Trevino.
The AT decision is not supportable. The claimant was approved for PUA benefits in July of 2020. The claimant stopped filing payment requests in early May of 2021 and believed her claim had been completed. Therefore, the claimant did not continue monitoring her TWC electronic inbox. Over 4 months later, the TWC sent the determinations to the claimant's electronic inbox. The claimant was not aware of these determinations because she was not in claim status and was not expecting to receive documentation from the commission. The commission's delay in sending these determinations to the claimant constituted commission misinformation, and the claimant's appeal should be deemed timely. Reverse the AT, timely claimant appeal, remand.
The AT decision is supportable. The claimant said her appeal was filed late because she was not checking her electronic correspondent inbox at the time determinations were sent. Claimant was not so far beyond the end of her claim filing series that she was excused from the need to monitor her inbox for TWC correspondence. Since the appeal was late, prior determinations are late in effect. Accordingly, we should affirm the AT decision. Claimant filed a late appeal. She was ineligible for PUA beginning December 27th, 2020, overpayment of $2,484.
Timely claimant appeal, remand.
We will remand this case. And you can dissent on the remand if you wish.
We'll dissent.
Okay, short form dissent. I have it down. Thank you.
Case number 3378092, Commissioner Esparza.
The AT decision is not supportable. The employer had originally filed a timely response to an initial claim notice during the height of the pandemic and was granted chargeback protection due to a disaster-related work separation. Through no fault of the employer, the UI claim was voided due to an incorrect last employing unit issue. And the employer later received a chargeback notice under the refiled UI claim. The employer was understandably confused and justifiably thought that TWC had made an error. The late appeal and late protest should be excused for that reason, and because the employer contacted TWC for assistance and was not given effective help in understanding the conflicting notices, Under the original determination, the employer was clearly entitled to chargeback protection. Accordingly, we should reverse the AT decision. The employer filed a timely appeal. The employer filed a timely protest. No chargeback based on a disaster-related work separation. In the alternative, if my fellow commissioners are not ready to protect the employer's account based on the original determination that was voided, I could support finding the appeal and the protest timely and holding a rehearing to cover the chargeback issue.
The AT decision is correct. The charge liability decision was mailed to the employer on 6/29/22. The deadline for filing an appeal was 7/13/22. The employer received the determination in a timely manner, but did not realize they needed to file an appeal because the employer did not carefully read the determination. After speaking with the TWC representative about the matter, who advised the employer to file an appeal, the employer then filed a late appeal on 7/19/22. Not carefully reading the determination does not excuse appeal deadlines, and the employer raised no other exceptions to the timeliness rules. Affirm the AT, employer appeal not timely, late response to the notice of maximum potential chargeback, charge the employer's account.
Timely employer appeal, remand.
Yes, yes, we will timely employer appeal and remand. We'll remand the case. And you can dissent on a remand decision if you wish.
I'll short form dissent on the remand decision.
Yes, sir.
Thank you.
Case number 3483746, Commissioner Trevino.
The AT decision is not supportable. The employer testified that the claimant was discharged for lying about attending a meeting on 11/17/22. However, the claimant was not sent an invitation to attend the meeting on 11/17/22. When he was asked about how the meeting went several days later, he answered regarding a meeting he attended on 11/18/22, because he reasonably believed that that was the meeting that he was being asked about. As far as the employer's further allegations that the claimant was also discharged for poor performance, the employer failed to establish that the claimant was ever able to meet their performance expectations and failed to provide evidence that the claimant engaged in actions that were egregious enough to be considered misconduct connected with the work. The claimant filed a timely CA appeal, reversed the AT, no misconduct, bill reimbursing employer.
We should affirm the AT decision. First, I agree that the claimant's appeal to the commission was timely. Concerning the job separation, as part of the claimant's performance improvement plan, he was advised to attend the employer's program meetings and to follow employer directives. The claimant was terminated when he violated the employer's specific instructions to attend the meeting. Moreover, when the employer confronted the claimant, he fabricated a lie for missing the meeting. Since the claimant was on a performance improvement plan, and because he violated specific employer instructions related to work performance, the claimant mismanaged his position of employment. As such, we should find the claimant's appeal to the commission as timely and affirm the AT decision. Misconduct, reimbursing employer not billed.
Timely commission appeal, misconduct, reimbursing employer not billed.
Short form dissent.
Yes, sir.
Case number 3518138, Commissioner Esparza.
We should modify the AT decision. First, regarding the claimant's failure to appear at AT1, because no one was checking the claimant's mail for almost 6 weeks while he and his wife were away from home. And he chose not to update his address with TWC during that time. The claimant did not have good cause for his non-appearance. Concerning the timeliness of the employer's appeal, the employer provided credible testimony that despite checking the mail daily, the termination was received after the deadline to appeal had passed. Thus, the employer's appeal should be deemed timely and the case resubmitted for merits. Accordingly, we should modify the AT decision. The claimant did not have good cause for missing AT1. The employer filed a timely appeal, resubmit the case for merit testimony from AT1.
The AT decision should be modified. I agree that the claimant had good cause for missing AT1. By the time the AT1 hearing was scheduled, the claimant had found new employment and stopped filing payment records. The claimant was unable to regularly check his mail because of the new job required him to travel out of town frequently. Since the claimant missed the hearing because he had begun new work, the claimant had good cause for his failure to appear at AT1. However, as to the timeliness of the employer's appeal, the employer's testimony about when it received the initial determination was both inconsistent and uncertain. Therefore, the employer failed to rebut the presumption of receipt, and the employer's late appeal should be dismissed for lack of jurisdiction, and the initial determination dated 9/15/22 should be reinstated. Modify the AT. Claimant had good cause for AT1, late employer appeal, no misconduct, chargeback. However, if my fellow commissioners do not agree that the employer filed a late appeal, I would agree to affirm the portions of the AT2 decision, granting the claimant's petition to reopen and deeming the employer's appeal timely. The claimant had good cause for AT1. Timely employer appeal, resubmit for the merits.
Claimant established good cause for AT1 and timely employer appeal resubmit.
We will resubmit the case.
Case number 3552-520, Commissioner Trevino.
The AT decision is not supportable. The claimant's appeal to the commission should be deemed timely because he changed his address of record during the appeal period. Regarding the separation, the claimant was the only one to appear at the hearing and testified that, in response to the coworker yelling at him in the workplace, he yelled back at the coworker and used some mildly inappropriate language that was inadvertently overheard by a customer. The claimant was not aware that the customer could hear him and that the language he used was not egregious enough to be considered misconduct. Deem the claimant's CA appeal timely and reverse the AT. No misconduct, chargeback.
I agree that the claimant's CA appeal should be deemed timely. As to the job separation, the AT decision should be affirmed. The claimant was fired for using inappropriate language at the workplace that was heard by a customer. While the claimant may not have intended for the customer to hear his use of said language, it nonetheless occurred. Moreover, the claimant was in a workplace setting at the time the final incident took place and should have been on his best professional behavior, regardless of whether he thought anyone was watching or listening. Since the claimant admitted to the final incident, his actions constituted mismanagement of his position and misconduct connected with the work. We should therefore hold the claimant's CA appeal timely and affirm the AT decision. Misconduct, no chargeback.
Timely commission appeal, misconduct, no chargeback.
A short form dissent, ma'am.
Yes, sir.
Case number 3559-500, Commissioner Trevino.
The AT decision is not supportable. The claimant provided testimony under oath denying that he was drinking or in possession of alcohol while at work. A coworker asked the claimant to throw away an empty bottle, and throwing out the empty bottle did not violate the employer's policy, as the claimant never possessed any alcohol while at work. Though this case was scheduled for a rehearing, the employer still failed to provide any firsthand testimony. The employer's exclusively secondhand hearsay testimony and evidence are insufficient to overcome the claimant's sworn denials, and the employer failed to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. When he filed for benefits, the claimant provided TWC one reason for his job separation and changed his story when confronted with the employer's response to that claim. As such, his denial of wrongdoing is neither credible nor persuasive. In contrast, the employer's thorough investigation and credible documentary evidence established that the claimant violated the employer's drug and alcohol policy while on the production floor. Thus, because the employer met its burden of proving that the claimant mismanaged his position of employment, disqualification is fully supportable. We should modify the AT decision, misconduct, no chargeback, sever the adequate response,
No misconduct, chargeback, void adequate response.
short form dissent.
Yes, sir.
Case number 3559981, Commissioner Esparza.
We should modify the AT decision. First, I agree that the employer's protest was timely. Concerning the merits, upon the claimant's job separation, the employer, a PEO, was given notice and specific instructions for the claimant to contact the employer within 24 hours of the assignment end date. Although the claimant acknowledged the employer's written instructions, she did not contact the employer within the requisite time frame for further assignments. She claimed, since the claimant was aware of the employer's rules, but thereafter failed to make herself available for further assignments, the claimant's separation was voluntary quit without work connected to good cause. As such, we should modify the AT decision, timely employer protest, voluntary leaving, no chargeback, sever adequate employer response.
The AT decision should be modified. I don't dispute the ruling on the timeliness issues of the protest issue. Regarding the separation, the claimant was released from her assignment on Friday, 8/6/21, and she reported for another assignment on Monday, 8/9/21. The claimant reported her availability by the next business day because she reasonably believed that she was not required to report availability over the weekend, when she did not normally perform work. Therefore, the claimant was laid off due to lack of work when she reported for reassignment and was not offered additional work. Modify the AT, timely employer protest, no misconduct, chargeback, void adequate response.
Timely protest, voluntary leaving, no chargeback, sever adequate response.
Short form dissent, ma'am.
Yes, sir.
Case number 3612608, Commissioner Trevino.
The AT decision is not correct. The employer testified the final incident that led to the separation that the claimant was late to work on 5/13/23 and absent from work without notice on 5/14/23. However, the evidence established that the claimant provided notice of her late arrival and absence due to an emergency situations to an investor in the employer's business, which was the individual involved in the daily operations of the business. The employer provided no evidence that the claimant knew or should have known that this notice was improper. Additionally, the employer's testimony lacked credibility, as the employer gave one reason for the termination in its prior statement to the commission, and then an entirely different reason in its testimony. The employer failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct. However, if my fellow commissioners do not agree that the claimant should be qualified based on the existing record, I would agree to rehear this case to admit the claimant's additional documentation into evidence and question the parties regarding the text messages that the claimant provided that support her testimony regarding the events of 5/14/23.
The appeal tribunal decision should be affirmed. Claimant was fired due to her attendance issues. Indeed, the final incident consisted of the claimant missing work without notice for a personal reason. Notably, this occurred one day after the claimant was late for work. Because the claimant was absent without notice on the day of the final incident, she mismanaged her position of employment, which amounted to misconduct connected with work. We should therefore affirm the AT decision with misconduct.
Rehear.
We will rehear the case. And Commissioner Esparza, did you have any questions about a prior case?
No, ma'am.
Okay, I just wanted to make sure.
Okay, thank you.
All right, that was the last UI case pulled for additional discussion on docket 4. You should have received the UI short form dissent list for docket 4.
I move we accept staff recommendations on the remaining UI cases on docket 4, except for the cases on which I am dissenting as reflected on the UI short form dissent list for docket 4.
I second the motion except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 4.
I concur with the chairman's motion, except for the cases in which I am dissenting as reflected on UI short form dissent list for docket 4.
Motion passes with the exceptions noted.
Thank you. Moving to docket 5.
Case number 3126287, Commissioner Sparsa.
We should deem the employer's appeal to the commission timely. Under TWC's timeliness rules, if a party updates its mailing address during the appeal period, the date of the address change is considered as the date of the appeal was perfected. Commission precedent expanded this concept to include electronic correspondence. The precedent holds that a party's election to receive electronic correspondence is equivalent to a change in its mailing address for appeal purposes. Here, the employer elected to unsubscribe from the electronic correspondence during the appeal period. While electing to no longer receive electronic correspondence is not specifically addressed in the precedent, the rationale is the same. The employer changed its method for receiving correspondence from TWC. This too is equivalent to a change in a party's mailing address for appeal purposes. Thus, because the employer updated its electronic correspondence selection during the appeal period, we should deem the employer's commission appeal timely and resubmit the case for merits testimony.
The employer filed a late appeal to the AT decision. The employer received the decision prior to the appeal deadline, reviewed the decision, and made the decision not to appeal. The employer later changed their mind and filed a late appeal. Dismissed the employer's CA appeal as late. The AT decision remains in full force and effect. Late employer protest, valid claim, no misconduct, chargeback.
Timely commission appeal resubmit.
We will resubmit the case.
Case number 3282301, Commissioner Sparsa.
We should modify the AT decision. First, I agree that the employer established good cause for missing the AT hearing. Concerning the reimbursement issue, the claimant worked as a substitute teacher for the employer, a school district. Although the employer made various attempts to contact the claimant about the availability of future job assignments, the claimant never responded to the employer's offer of further work. Since repeated attempts were made to advise the claimant about future work assignments, but the claimant refused to acknowledge or accept the employer's job offerings, the claimant voluntarily quit without work-connected good cause, and the employer's account should not be billed. As such, we should modify the AT decision. The employer established good cause for missing the AT hearing, reimbursing employer not billed.
The AT decision is correct. I won't dispute that the employer had good cause for missing AT1. However, the evidence established that the claimant worked for the employer as a substitute teacher, working on an as-needed basis, without knowing from day to day when further work would be available. Therefore, the claimant was involuntarily separated from employment at the end of each substitute teaching assignment. Since this is not a disqualifying work separation, the reimbursing employer should be billed. Affirm the AT, employer had good cause for AT1, bill reimbursing employer.
Employer established good cause for AT1, bill reimbursing employer, memo to investigate suitable work.
Suitable work.
Suitable work.
Okay, we will send that memo.
I'm going to short form dissent.
Yes, sir.
Case number 3506811, Commissioner Sparsa.
We should affirm the appeal tribunal decision. The claimant quit her job due to lack of childcare. Longstanding commission precedent has established that childcare issues do not constitute good cause connected with the work for quitting. Furthermore, in determining whether a job is suitable for purposes of section 207-045 G1 of the Act, the childcare considerations are not a factor under the statute. Therefore, since the claimant quit without good cause connected with the work, the disqualification and resulting overpayment are appropriate. Affirm the AT decision, voluntary leaving, overpayment of $381.
The AT decision is not supportable. The claimant resigned from her position after working for one full day for the employer. She was unable to return to work because she did not have adequate childcare. The hours that the claimant was assigned to work were not sustainable for the claimant to continue working for the employer. Under section 207.045 G1 of the Act, the claimant had good cause for quitting because she was receiving benefits when she took the job. The work was not suitable due to the claimant's need for childcare, and the claimant worked less than 4 weeks for the employer. Reverse the AT, no voluntary leaving, no overpayment.
Voluntary leaving, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3545650, Commissioner Sparsa.
Commission should grant a rehearing in this case. It is unclear who initiated the job separation. The employer contends that the claimant quit, while the claimant argues that she was discharged. The employer stated that the claimant was notified she needed specific equipment to continue working for the employer. However, there is also evidence to indicate that the claimant moved, as a result, could not comply with the employer's equipment requirement. We should rehear the case to further develop the following issues. 1, when did the claimant move? Was it prior to the employment notifying her about the equipment requirement, or was it afterward? 2, did the employer specifically notify the claimant that she could be terminated for not having the appropriate equipment to perform the work? And finally, 3, did the employer ever assume responsibility for providing the claimant with a specific piece of equipment to perform her job, which in this case appears to have been an Ethernet cable? As such, we should rehear this case for the reasons so stated.
The AT decision is not supportable. The claimant did not resign due to equipment or scheduling limitations, as these conditions had been accommodated by the employer. It was only once the job that the claimant was working on ended that the employer discharged the claimant because the work that was then available did not meet her limitations. Since the employer initially agreed to accommodate the limitations, the claimant later inability to accept available work due to the required equipment and schedule did not constitute misconduct connected with the work, and the claimant was laid off due to lack of work. Reverse the AT, no misconduct, chargeback, avoid adequate response.
Voluntary leaving, no chargeback, sever adequate response.
Short form dissent, ma'am.
Yes, sir. Now, we do not yet have a majority vote, actually, because you voted to rehear.
I'll amend mine to support the chairman's.
Okay, majority vote is misconduct, no chargeback, sever adequate response, and I have your short form dissent.
Thank you, ma'am.
Mhm.
Case number 3547431, Commissioner Sparsa.
We should reverse the AT decision. The employer's policy prohibits employees from using its 911 equipment to search and access information for personal gain. The claimant was terminated when she admitted to using the 911 equipment to obtain information on a family member in a non-emergency situation. Since the claimant acknowledged the employer's confidentiality rules specifying the importance of strict confidentiality due to the sensitive nature of the employer's work, the claimant's use of the employer's equipment for personal use was mismanagement. As such, we should reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response. In the alternative, if my fellow commissioners disagree, I can also agree to rehear this case to obtain information on when the employer learned of the claimant's infraction and whether this resulted in a delay between the time of the final incident and the job separation. Rehear.
The AT decision is correct. The evidence established that the claimant resigned in lieu of discharge. Therefore, the work separation was involuntary. The employer's witness could not provide any specific reason for why the claimant was subject to discharge, and the only incident referenced to during the hearing occurred several months before the claimant's separation. Therefore, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
Rehear.
We'll rehear.
And we'll rehear the case. I did want to go back one and confirm the vote. So the fourth case, case number 35456. Case number 3545650. I'd like to confirm the vote. Commissioner Esparza, could you repeat your vote for that case?
So initially, I voted to rehear.
Yes, sir.
Upon the chairman's vote, I amended to concur with the chairman.
Thank you. Could you repeat your vote, sir?
Voluntary leaving, no chargeback, sever, adequate employer response.
Voluntary leaving, no chargeback, sever, adequate response. And I still have your short form dissent. Just wanted to confirm that I had repeated voluntary leaving and not misconduct. So it is a voluntary leaving case. Proceeding to the next case, please.
Case number 3572254, Commissioner Trevino.
Okay, can you read the number again just to make sure? It's
Three.
3572254.
4, yes.
Okay. The AT decision is not supportable. The employer discharged the claimant for alleged poor work quality. The claimant provided sworn testimony denying that his job performance was insufficient. The employer failed to offer any testimony or provide any specific evidence showing that the claimant's work quality had decreased or that his job performance was inadequate. Therefore, the employer did not meet their burden of showing that the claimant engaged in actions that could be considered misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should affirm the AT decision. While on a final warning for attendance, the claimant continued to be absent. As such, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3572843, Commissioner Trevino.
The AT decision is not supportable. The claimant was discharged for poor attendance after missing work due to flight delays the day after Christmas. The claimant had scheduled her holiday air travel in such a way as not to interfere with her work schedule. And when she realized that it would not be able to attend work due to the flight delays, she contacted her supervisor to report her absence. Though the claimant had previous attendance warnings, the claimant's actions did not contribute to her failure to report for work, and therefore the claimant's actions did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
The AT decision should be modified. The claimant was terminated for excessive absenteeism. The claimant had received a final warning advising her that termination could result if her attendance did not approve. Nonetheless, the final incident consisted of the claimant being absent from work without notice. As such, the claimant mismanaged her position of employment and was discharged for work connected to misconduct. We should therefore modify the AT decision to misconduct, no chargeback, sever adequate employer response.
No misconduct, chargeback, void adequate employer response, and a memo to investigate possible unreported earnings.
Short form dissent.
Yes, sir. And we'll send that memo.
Case number 3573372, Commissioner Esparza.
Commission should grant a rehearing in this case. In its appeal to the commission, the employer offers to submit video evidence of the final incident. Since both parties dispute what occurred or what did not occur during the final incident, a video of the same would be compelling to view and could change the outcome of the case. Accordingly, we should rehear for submission of the employer's video evidence.
The AT decision is correct. The claimant instructed a hostile inmate to remove her head covering for a photo. Then the inmate began to struggle and forcibly swung her hand towards the claimant. The claimant felt something strike her in the face and filled out an incident report stating that the inmate's hand had struck her. During an investigation, the claimant acknowledged that she was not entirely certain if it was the inmate's hand or the head covering that struck her, but she believed that it was a hand based on the force of the blow. The employer then discharged the claimant for making a false report After concluding that the inmate's hand did not contact the claimant's face. Since both the claimant and the credible firsthand witness confirmed that the claimant was forcibly struck in the face by an inmate, uncertainty of whether the assault was from the inmate's hand or the head covering was not an intentional misreporting of the incident and did not rise to the level of misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
Rehear.
We will rehear the case. And that was the last unemployment insurance case pulled for additional discussion on docket 5. You should have received the UI short form dissent list for docket 5.
I move we accept staff recommendations on remaining UI cases on docket 5, except for the case on which I'm dissenting as reflected on the UI short form dissent list for docket 5.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 5.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in UI short form dissent list for docket 5.
Motion passes with the exceptions noted.
Thank you, gentlemen.
Thank you. This brings us to the end of agenda items 1 through 8. We'll take a short recess.
Hey.
Mr. Trillman.
Yes, Commissioners, we do have Ms. Howard, Jennifer Howard, if you can unmute yourself and present.
Hello,
Yes, good morning. Go ahead.
good morning. I was calling in because I had an appeal that was on January 24th. January 10th of 2024. And the end results of that appeal that was presented on January 12th were I did not understand the ending results, and it said it was reversed the previous ruling. Also, we voided the determination on appeal. That did not clarify what exactly was determined. Was I no longer going to receive the benefits, or am I going to receive the benefits? And that's the clarification that just I did not have.
Thank you, Ms. Howard, and we'll have our unemployment insurance department reach out to you directly on that. Commissioners, that's what we got.
All right, thank you. This is agenda item 9, unemployment trust fund balance.
Good morning, Chair. Turn it. That we would project on September 30th, 2024. We started on October 1st of this year with a $2.2 billion balance. Right now, we're projecting to collect $2.2 billion in revenue. And then we're expecting to pay out $2.34 billion in unemployment insurance benefits for the year, leaving a projected balance of $2.1 billion on September 30th, 2024. That would be above the floor and below the ceiling for that time period, which would be about $2.6 billion for the ceiling and $1.3 billion for the floor. We also project to have an employment and training investment account assessment balance of $343 million as of September 30th as well. And that concludes my remarks, and I'd be happy to answer any questions.
Any questions, comments?
None here.
No questions.
Thank you.
Thank you.
It's agenda item 10, proposed rules for 40 TAC chapter 813 SNAP ENT.
Good morning, Chairman, Commissioner Trevino, Commissioner Esparza, Mr. Serna. For the record, I'm Joel Mullins with Workforce Development. Commissioners, before you today, for your consideration for approval, are proposed rule amendments to Chapter 813 on the SNAP Employment and Training Program. These proposed amendments will amend the Chapter 813 rule language to conform with SNAP provisions of this Fiscal Responsibility Act, revise references to the case management system, and update the allowable activities for able-bodied adults without dependents. Additionally, staff reviewed Chapter 813 for its statutorily required 4-year rule review and addressed the review in the proposed rules preamble. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period, and also requests the ability to make minor non-substantive changes to the document to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm happy to answer any questions.
Comments or questions?
No questions.
No questions.
Is there a motion?
Chairman, I moved to approve the proposal of amendments to 40 Texas Administrative Code Chapter 813 Supplemental Nutrition Assistance Program Employment and Training for publication in the Texas Register and public comment as recommended today by staff.
I second.
Been moved second, motion carries. This
Thank
is
you.
agenda item 11, 2025-2026 child care market rate survey and cost of quality price modeling.
Good morning, Chairman, Commissioners, Mr. Serna. For the record, Allison Wilson with Child Care and Early Learning Division. In June of last year, you approved the fiscal year 2024 statewide initiatives budget, which included funding for the annual child care market rate survey and cost of quality price modeling report. The 2024 reports are scheduled to be delivered this June. TWC contracts with UT's Ray Marshall Center to complete both the market rate survey and the cost of quality reports. While the market rate survey is published annually, the cost of quality report is published for licensed child care centers every odd-numbered year and for family child care homes every even-numbered year. To cover the requirements of the alternating years, TWC will enter into a 2-year contract with UT beginning July 1st for the 2025 and 2026 market rate surveys and cost of quality reports. There is currently not enough funding in the FY24 budget to fund this upcoming 2-year contract. Therefore, staff is requesting that the Commission approve statewide initiative funding. We are requesting $800,000 in fiscal year 25 for the 2025 market rate survey and cost of quality report for centers, and $800,000 in FY26 for the 2026 market rate survey and cost of quality report for homes. That concludes my remarks, and I'm happy to answer any questions.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move to approve the funding in the amount of $1.6 million for the 2025 and 2026 child care market rate surveys and cost of quality price modeling studies, as described in the discussion paper and recommended today by staff.
I second.
Been moved second, motion carries.
Thank you.
Agenda item 12, AEL Advisory Committee Annual Report.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Serna. For the record, Mahalia Baldini, Workforce Development Division. Texas Labor Code, Chapter 315.005 requires that the Texas Workforce Commission establish an Adult Education and Literacy Advisory Committee, which is charged with reporting to the commission annually and advising the commission on various aspects related to the enhancement of adult education here in Texas. I want to thank all of our advisory committee members for their contributions over the last year that led to today's report. I have with me today our advisory committee's presiding officer, Steve Banta, who is also the executive director of Literacy Texas, at least for a couple more months. He's actually going into retirement here very soon, and we wish him well. He will be addressing the commission today to present the 2023 annual report. Once he concludes his remarks, I will provide a brief summary of the work conducted over the past year by TWC to be responsive to the recommendations. At this time, I'd like to welcome Steve Banta.
Thank you, Mahalia. For the record, my name is Steve Banta, Executive Director of Literacy Texas. Good morning, Commissioners. Since you have been briefed on the details of our committee's recommendations, I will provide some highlights for you. The AEL Advisory Committee focused on best practices when discussing AEL services across Texas and heard from several very successful programs. Highlights from these discussions were incorporated into our 2 recommendations to this commission. If there is a theme, it is that successful programs have found a way to collaborate with other social service programs to provide the wraparound services students need to be successful. The first recommendation focuses on employers. Texas employers provide one of the best ways to prepare students for employment. To this end, we encourage TWC to continue to develop projects and partnerships like the Talent Pipeline Management System that trains prospective workers with specific skills that meet the employer's needs. This also creates the opportunity for TWC to develop standardized curriculums that could include employability and digital literacy skills to meet employer needs. The second recommendation focuses on state agencies and community-based organizations. The committee recommends that TWC examine ways to promote collaboration between agencies, jail prison-based programs, CBOs, and workforce solutions to create a no wrong door approach to better serve participants, avoid duplication, support continuity of services, and provide more efficient use of scarce resources. Some examples are create a statewide academy to educate frontline AEL workforce development and workforce solutions office staff about all services available, or create a data system that integrates all WIOA core partners to share participant data. Finally, you could also define a referral process for students leaving the corrections prison jail environment to connect with CBOs pre-entry and facilitate enrollment and transfer of records. The committee thanks Mahalia Baldini for her leadership and this commission for the opportunity to provide recommendations to address the very important topic of adult literacy in Texas. This concludes my remarks.
Thank you, Steve. I just wanted to take a moment to acknowledge for the commissioners some existing and ongoing work of our department and division to be responsive to the committee's recommendations. With regards to the committee's 2022 recommendations, which were brought forward to you last year, of working with employers on projects and partnerships that provide vocational and employability skills, specifically those of digital literacy skills, TWC contracted with the Texas Center for Advancement of Literacy and Learning to revise our adult education and literacy content standards to include specific standards for digital literacy. The rollout of the revised content standards to over 100 AEL providers across the state began in November of 2023 and will conclude those events this month. This will now require all adult education providers develop curriculum that will now include a digital literacy competency. The 2022 report also recommended a digital literacy and equity assessment to better understand the primary barriers that may restrict AEL students from accessing online services. In response, TWC staff are currently working on a policy change as well as a data system enhancement to require a comprehensive assessment at intake to collect those digital literacy skills and access related data points. This will allow us to better assess need and develop a statewide coordinated response. Also in 2022, the advisory committee recommended TWC examine ways to promote collaboration between our stakeholders to create this no wrong door approach. In response, TWC staff worked in partnership with Region 6 Educational Service Center, who is our contractor for our Career Pathway Professional Development Center, to launch the very first Workforce Integration Academy. The first step, an initial academy focused on professional learning activities around bridging the gap in knowledge of adult education leadership with board programs and services to ensure there is awareness and referrals between partners. After feedback from staff, as well as some attendees for our first academy, we will be revising and making a second iteration of the academy and expanding our stakeholders to include employers. Again, I just wanted to thank Steve for his leadership over the past 2 years and all of our advisory committee members for their dedication and continued commitment to serving adult learners here in Texas. This concludes my remarks.
Any comments or questions?
I just want to thank staff and you, Mr. Banta, and committee members for their commitment, hard work, and expertise in improving the quality and effectiveness of our AEL program.
Thank you, sir.
No questions, but I second Commissioner Trevino's remarks and enjoy your retirement, Mr. Benton. And thank you for your work on this advisory.
Steve, thanks so much. Mahalia, as always, lots of great work going on. Steve, we don't celebrate our volunteers enough. All we can really do is say thank you. I really appreciate all you've done. You've really helped advance the issue to the point where it's very actionable for this commission, and I really appreciate that. That's difficult to do in this day and age. All right, anything else?
That's it.
Thank you. This is agenda item 13, AEL Advisory Committee members.
Just to keep it interesting, I'm going to come over here. Good morning again, commissioners. For the record, Mahalia Baldini with the Workforce Development Division. Texas Labor Code, Chapter 315.005, as well as the Administrative Code Rule, Chapter 805.43, require that the Texas Workforce Commission establish an Adult Education and Literacy Advisory Committee. The committee must not be composed of more than 9 members and must include at least 1 representative from our business community, as well as 1 representative from a local workforce development board. For your consideration today, staff recommends the appointment of 2 new members, Ernest Lewis, Senior Director of Economic Initiatives for Baker Ripley, as well as Carla Flanagan, who is the Associate Vice Chancellor of Instructional Alignment and Innovation at the Texas State Technical College. Staff are also recommending the reappointment of Janine Maldonado, who's the Director of Adult Education for Workforce Solutions, Tarrant County. If approved, all 3 members would enter into a 2-year term that would expire in January of 2026. I'm happy to answer any questions that you may have.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move we appoint the following individuals to serve on the Adult Education and Literacy Advisory Council for 2-year terms expiring in January of 2026. Janine Maldonado, Ernest Lewis, and Carla Flanagan.
A second.
The move second, motion carries. Thank you. So agenda item 14, WIOA Combined State Plan for program years 2024 to 2027.
Good morning again. For the record, I'm Joel Mullins with Workforce Development. The Workforce Innovation and Opportunity Act requires that in order to be eligible to receive funding for WIOA core programs, titles 1 through 4, the governor of each state must submit a unified or combined state plan to the U.S. Departments of Labor and Education. On December 12th of 2023, the commission approved the program year 2024 to 2027 WIOA combined state plan for posting for public comment. From December 24th of 23 through January 13th of this year, TWC solicited comments from representatives of workforce development boards and chief elected officials, representatives of agricultural organizations, community-based organizations, adult education providers, institutions of higher education, and the public. During that time, TWC received one comment relating to the alignment of education and workforce partnerships. The plan was updated to summarize and respond to the comment, but no other changes were made to the plan related to that comment. Additionally, on January 10th of 2024, the U.S. Department of Education Rehabilitation Services Administration released additional plan guidance regarding the VR program. And in response to that, staff amended the plan to describe collaborative efforts between TWC and state and local educational agencies to improve employment outcomes for individuals with disabilities. This morning, staff recommends approval of the proposed combined state plan for transmittal to the Texas Workforce Investment Council and the governor for submission to the Departments of Labor and Education. And I'm happy to answer any questions.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move to approve the Workforce Innovation and Opportunity Act Combined State Plan for program years 2024 to 2027 for transmittal to the Texas Workforce Investment Council and the Office of the Governor for submission to the United States Departments of Labor and Education as recommended today by staff.
I second.
It's been moved and seconded. Motion carries. Thank you.
Thank you.
So agenda item 15, internal audit charter.
Good morning, Chairman, Commissioners. For the record, Ashley Sogaville, Director of Internal Audit. The Internal Audit Charter is a formal document that defines the internal audit's purpose, authority, and responsibility. This document should be reviewed and revised periodically to ensure all information is up to date and accurate. Today, I'm here to present the Internal Audit Charter as discussed with your offices for your consideration and approval.
Is there any comments or questions?
No comments.
No questions.
Is there a motion?
Chairman, I move to approve the Internal Audit Charter as recommended today by staff.
I second.
It's been moved and seconded. Motion carries. This is agenda item 16, fiscal year 2024 internal audit plan.
Again, for the record, Ashley Sogaville, Director of Internal Audit. I'm here to present the fiscal year 2024 audit plan for your consideration and approval. On page 7 and 8 of your materials, you will find the proposed audit projects as briefed with your offices. And I'm happy to answer any questions you may have.
Is there any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move to approve the fiscal year 2024 internal audit plan as recommended today by staff.
I second.
Motion is moved and seconded and motion carries. Thank you. It's agenda item 17, fiscal year 2023 annual and supplemental reports.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Cerna. To everyone who's not statutorily required to have a good morning, I hope you do anyway. For the record, my name is Matthew Mazer with Outreach and Employer Initiatives Division. Before we get started, I'd like to take a moment to acknowledge all those who contributed to these reports. From content contributors to accessibility remediators, many people across several divisions put a lot of their time into these reports. And then I put that into size 11 Calibri font. I hope one day we can do it all over again. Before you today for consideration are the fiscal year 2023 TWC annual and supplemental reports. The annual report has been produced in compliance with Texas Labor Code Section 301065 for submission to the governor and Texas legislature pending commission approval. Also before you is TWC's supplemental report produced in accordance with Texas Labor Code Section 301065, which requires TWC to submit a separate supplemental annual report consisting of any information required by other law to be included in the supplemental annual report. It contains annual information for the following programs: College Credit for Heroes, Skills Development Fund, Trade Adjustment Assistance, and Works Wonders Texas purchasing from people with disabilities, all of which are required under the law. Staff also requests the ability to make minor, non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. That concludes my presentation. Staff are available from all relevant programs to answer any questions about either of these reports.
Comments or questions?
None here.
No question. Thanks.
I do have. We can do this one of two ways. I have an amendment to the motion. So why don't we go ahead and put the motion on the table and then I'll introduce my amendment. I'll tell you about it.
Okay. Chairman, I move to approve the fiscal year 2023 annual and supplemental reports for submission to the governor and legislature as recommended today by staff.
I'll second that motion. I do have an amendment to the motion. So this is a legislative report. I noted in the commissioner's message that we talked about some programs that the legislature had amended for the new biennium. We did not talk about some others. I asked staff to draft an amendment that would encompass everything the legislature either gave us new, changed the dollar amount on. In other words, I wanted to acknowledge to the legislature that we had taken under advisement and work all of the elements that they had changed in the last legislative session. I've distributed here to the other commissioners what staff's proposed language looks like. It looks good to me. They simply went in and captured that. So I would move we adopt this amendment.
I second the motion to adopt the amendment of the.
Is there any objection to adopting the amendment? Hearing none, the amendment's adopted. Is there any objection to adopting the amended motion? Hearing none, the motion is adopted unanimously. Before we move on, Mr. Trowman, can we get some complete report as to who is statutorily required to have a good morning? Because I have not been, and I want to make sure I'm not violating the law. Thank you, guys, very much. This is agenda item 18, board nominees.
Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And today for your consideration, we present Workforce Board nominations for Workforce Solutions, North Central Texas, Greater Dallas, Lower Rio Grande Valley, North Texas, and Permian Basin. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move to approve the local Workforce Development Board member nominees presented today for the following: Workforce Solutions, North Central Texas, Greater Dallas, Lower Rio Grande Valley, North Texas, and Permian Basin.
I second.
It's been moved and seconded. Motion carries. Thank you. I do not see any evidence of a legislative report today. Is there an executive director's report?
Excuse me, sir. No, sir, there's not that either.
All right. Is there any other order of business come before the commission?
I have one comment for Ed. Staff has briefed the offices on the final apprenticeship Chapter 133 contact hour rate. And due to the increased number of apprentices, the contact hour rate will be $2.80 per hour, which is well below the TWC recommendation of $4 per hour. On June 13th of 2023, the commission approved the fiscal year 24 budget with the amendment that the reduced Chapter 133 funding by $650,000, with the understanding that if necessary, we could restore it. I would like staff to bring forward a discussion paper with options that explore restoring the WIOA funding to apprenticeship and options to maintain the $4 contact hour rate. Now, due to the importance of getting a contract signed, I'd like to request this discussion paper be expedited and briefed to the offices so that it can be brought forward for consideration at the February 6th meeting.
Yes, sir. We'll take care of that.
Thank you.
Any other business come before the commission?
None here.
Is there a motion to adjourn?
I move to adjourn.
A second.
It's been moved second to adjourn, and we're adjourned.